So, just to summarise what I'm going to talk about, it's first of all looking at the legal test. So what's the legal test that determines whether or not a university is or isn't subject to the procurement rules? And that's whether or not you're regarded as a contracting authority. Then I'm going to have a look at the impact there is on that test in relation to financing and what is regarded as public financing and therefore would be considered for the purpose of the test. And then look at the position now and also look ahead at some what-if scenarios, including things like the sell-off of the student loan book or privatisation of the student loan company. So, first of my topics, what's the legal test? Well, there it is in the legislation. It's a corporation established for the specific purpose of meeting needs in the general interest. And then one of the following three limbs has to be satisfied. And I've underlined the one that is sort of critical to what I'm talking about, and that is financed wholly or mainly by another contracting authority or subject to the management supervision of another contracting authority, or where more than half the board of directors or members are appointed by another contracting authority. And what's important for those three limbs, and you only have to satisfy one of them to come within the test, is the courts, and the European courts in particular, take a very functional and purposive approach to their interpretation. And what they're essentially looking at is whether or not there's any dependence between the funding organisation and the recipient, or the organisation that's managing and the organisation it's managing. So the key issue is dependence. So looking at that limb that we're most focusing on, it's this financed wholly or mainly by another contracting authority. And what does that mean in practice? Well, we go back to a case back in 2000 when it's a case involving the University of Cambridge, when they actually explored what that means in terms of financed wholly or mainly by another contracting authority. And the court said it's whether or not the funding is more than 50% public financing. So wholly or mainly means more than 50% or more. And then in looking at, well, what does public financing mean in practice? The court said it's awards of grants that are paid by one contracting authority to another for research work, say, that would be regarded as public financing. And similarly, back in the day, student grants paid by, as then was, local education authorities to universities would equally, for student tuition fees, would equally be regarded as public financing. What wouldn't be regarded as public financing, however, were sort of proper commercial arm's length term agreements whereby the university was providing services in return for a price. So payments that were received in return for services where they were commercial arm's length arrangements, they wouldn't be regarded as financed by, even if the payment was actually made by another contracting authority. So that was the way in which the court looked at it. And in the University of Cambridge case, what they determined is that actually the amount of public financing that Cambridge was receiving was less than the 50%, which therefore took them outside of the scope of the procurement rules. The other thing that the court said was, just because we've determined it this year, that doesn't necessarily mean that next year you would still be outside the procurement rules, because you have to look at it on an annual basis, because it depends on where your funding is coming from or where your finance is coming from in any particular year. So it's not something that you can just sort of draw a line in the sand and say, oh, in 2000 we were outside the rules, therefore forevermore we will be outside of the rules. It's always based on where is the funding coming from in that particular year. So when did this become a more topical issue? Well, it goes back to 2011 and the white paper that the government produced and the consultation that followed that. And in that white paper, BIS expressed a view as to what the impact of shifting student tuition fees from grants to loans, what impact that might have on the status of universities as contracting authorities and subject to the rules. And the quote there is what BIS said and the rationale for it. And they basically said, well, there's a contractual agreement between the student and the government, and therefore any public subsidy benefits the student, not the university. And the agreement between the student and the university to pay a tuition fee isn't public financing because it's coming from the student. And therefore the conclusion was that the shift from it being a grant to a loan meant that universities, or might mean that universities, depending on where their other funding was coming from, would fall below that 50% threshold and therefore be exempt from the procurement regulations. To which everybody said, hurrah! No more complying with procurement law. We took a slightly more cautious and measured view around whether or not that was the golden ticket, and that would mean that most universities would fall outside of the rules. And what we did was we decided that it was worth getting an independent opinion from a leading QC in one of the chambers that is a specialist in public procurement law. So we went to Philip Moser, who is at Moncton Chambers, and we asked him to consider the issue. And his conclusions were, and this is the logic that he followed, the student loan company who actually pays the tuition fee to the university is a contracting authority. There's no dispute about that. It is a public body. The student loan company funds are public funds because it receives them from government. It's actually the student loan company who pay the university the tuition fee, and that's not based on a contractual relationship whereby they pay the tuition fee, a fee in return for services. It's still akin to the sort of arrangements that were discussed in the University of Cambridge case and that were considered to be public financing. And even more than that, it doesn't have to be public financing, it doesn't have to be direct funding, it can be indirect. And what qualifies as indirect public funding? Well, there have been a number of European cases which have considered it. And what they've considered and where they've come out at is that if an arrangement is brought about by state measures and enforced by public powers, then that can be regarded as indirect funding. And the examples that have been used and which these European cases have been based on are, for example, licence fees, which are actually paid by licence holders, so the public, to public broadcasters, but where the licence fee payable is both calculated and levied by state measures. And similarly, a situation where you have a statutory insurance fund, which is still financed by members' contributions, but where the scheme rules itself are fixed by the state, that can still be regarded as indirect public funding. So that brings us to the conclusion that if you follow the logic in those cases, the funding of universities by the student loan company does meet the test for indirect public funding, as it's both brought about and enforced by state measures and powers. There's statutory regulation around student repayments, which are compulsorily recovered from future income. It may never be recovered in some circumstances, and we know that the SLC has already got issues about the amount of the loans that it is able to recover and has been able to recover. And we know that if the income threshold is never met, then the student never has to repay the loan at all, which means that that would be direct public funding, because the student loan company would have paid for the tuition fee. And going back to where I started in terms of those three limbs and the purposive and functional approach to their interpretation, there must be a real dependence between the university and the student loan company, because universities rely on those payments received from the student loan company. They don't rely on the students to pay the tuition fee. They rely on the student loan company to do that. And therefore, I think you automatically then have that dependency relationship, which brings about the satisfaction of the test. And therefore, the firm's, Mills and Reeve's conclusion, and I know that there are other firms who perhaps don't agree with our view, but we think that we're right, or we would, and we are backed up, as I said, by leading counsel. And I think the logic is right, that even though it is now a student loan and not a grant, the arrangements and the statutory basis upon which it is built will still take it into the public funding category. And therefore, I don't think that the fact that you now have student loans for tuition fees makes any difference to a university's status as a contracting authority. And I don't think that you can regard that as funding which isn't public funding when you're carrying out the test. So I'm sorry if that's bad news. And I know that some universities have taken quite a bullish approach and are following the line of argument of BIS. But it is quite interesting to see that BIS did caveat their view by saying, and it will be for universities to take their own legal advice on this. So they weren't prepared to give an absolute guarantee on the point. And I don't think they've said a great deal since they made the statements back in 2011 and in the consultation. So that's my view and the firm's view as to the position that you're in now, but what might the future hold? Well, who knows? But if, for example, everything is privatised, if the scheme, if the whole regulation around payment of tuition fees and student loans, if that all changes such that it would no longer be regarded as state measures enforced by public powers, and or if the student loan company is privatised such that the loan is no longer public funding, but it's private financing which actually meets the cost of the loan initially, then that might well very much change the position, because you could well be looking at a situation where it was no longer public financing, and therefore it might lead to more instances of universities falling outside of the rules. But I think that's the future. We don't know what is going to happen in the short term. I don't think the fact that the government is considering a sell-off of some of the existing loan book debt makes much difference, because that relates to historical loans that were based on mortgage-based loans for maintenance grants and not tuition fees. So what's currently in the pipeline in terms of the sell-off, I don't think is going to make much difference. But if it starts to look at sell-off in relation to the loan book for tuition fees and or the student loan company is privatised, then I think we could be into a whole new arena.